time to vet and even less time to interview prospective grand jurors. It was a much more of a hit and miss proposition with predictable outcomes. You don't need me to tell you that one of the most important ingredients which determines the success of a civil grand jury is the recruitment screening process. People who slip through the cracks, who are single issue folks, who have an axe to grind, angry partisans, or domineering personalities who simply don't work well in groups. Getting on grand juries changes the complexion of a grand jury for an entire session. And unfortunately, as we all know, the occasional rare bad grand jury outcome that becomes a matter of public record reflects on every grand jury in the state. So the recruitment process, the recruitment screening process is vital, and the assistance that the local chapters provides to courts that invite it or to courts that they offer it to really makes a difference. Thanks to the programs and materials of CGJA and the vibrant county chapters, that process, certainly in my county, has been infinitely enhanced by what you do. And the PJ views the grand jury process in a transformed fashion in the bargain. A further word about your PJ and his or her relations with the grand jury. By law, the PJ is not all-powerful in grand jury matters. The presiding judge does not select topics or direct investigations or determine what goes in a report. The presiding judge has no part in grand jury deliberations generally, and usually only gets involved during the year if advice is sought or misconduct or discord issues develop within the grand jury. And of course, finally, the presiding judge reviews the final reports of the grand jury, but principally to ensure that they address subject matter within the jurisdiction of the grand jury. When it comes to legal advice, general legal advice, the presiding judge will usually defer to the legal advisor for the grand jury, the county counsel, almost reflexively. First, because that's the right place for grand juries to go for general legal advice, and second, frankly, because judges' frames of reference are generally to resolve disputes, not to advocate positions. So you'll find if a grand jury seeks general legal advice from the presiding judge, very frequently he or she will consult with the county counsel and ask the county counsel to return communication on the inquiry. As noted previously, presiding judges are under the gun from a time perspective, so when the grand jury does seek out a presiding judge, there is nothing approaching instant access by the grand jury or by anyone, unfortunately. Not because the grand jury is a low priority from the presiding judge's perspective. It is because the presiding judge has always time-sensitive priorities across the board. I might add as a helpful tip, for grand juries who wish to communicate directly with the presiding judge and have time-sensitive problems of their own, an excellent avenue is the court executive officer, who is really an effective intermediary between the presiding judge and an array of stakeholders. We all learned in school that the preservation of our democratic order depends in part on an effective judiciary. Trial judges know that as they daily address criminal and civil conflicts so as to ensure that the law is equally applied to all in a civilized and expeditious manner. Public service is the focus. Nurturing our democracy is the outcome. The trial judge routinely deals with disputes that illustrate the shortcomings of individuals and institutions, both public and private. In other words, judges are daily sensitized to the foibles and failings in our society while charged with making order out of the resulting disputes. It goes without saying then that most judges you will work with will appreciate the valuable contribution the civil grand jury makes in its watchdog role so as to inform voters and to cast a bright but fair light on the function of local government. By these means, unnecessary disputes can be avoided and potential failings thoughtfully corrected. In conclusion, most new presiding judges will be in a receptive frame of mind when first taking on grand jury duties. His or her task will be demystified and made easier by the services and products that CGJA provides, which will enhance the PJ's performance. Through your efforts, the civil grand jury system will thus be quietly making a new friend. That is a perspective to strive for. Thanks so much.
If there are any questions, please raise your hand. We'll get you the mic, and we'll do the best we can to give you an answer.
Betsy cannot ask a question.
John Jahr, one issue facing many grand juries, many counties in California is recruitment of new jurors. And some counties are a little more successful than others. We talk a lot internally with respect to what we can do to help the counties in any way possible to staff the grand juries. My question to you is, in the cases where counties are really struggling with respect to screening, can you give me your opinion with respect to accepting what I would call somewhat marginal kinds of jurors in order to empanel a few jury versus not being able to do so?
There's no right answer to that question.
That is a perfect question.
And it is interesting. I've kept track through the years via our court executive officer with the challenge associated with getting interested citizens to apply. And it seems, although every year is different, that if anything, the challenge is becoming more acute than some years back. We're not really quite sure why that is, but affirmative steps appear to be required if you're going to avoid the very dilemma that you outlined. Because to have substandard applicants is to have a grand jury that probably will function poorly. When it comes to recruitment in Shasta County, which is the only county with which I have any real familiarity, the local Grand Jury Association is very prominent and has been invited by the court and welcomed by the court to be engaged in that process. They put banners up, they advertise in the newspaper, I think on other media, and recruit and really promote, and it appears to have had a positive impact. Not just amongst people who are retired, who obviously are central to the successful recruitment, but also for people who are in mid-career. So I would say, and incidentally, county government really isn't involved in that process at all. County government is responsible financially to support the grand jury, and we all know that that itself is a challenge these days. But to find a way to mesh with your court so that it will be welcoming to the kind of assistance that the local chapter can provide, I think is the first essential step in avoiding the very dilemma that you outlined. And it can be done. I know that there are courts that are hesitant to accept that kind of responsibility, I should say delegation, but it's not really a delegation. The court is maintaining its responsibility to make the selections, but it's allowing others, people with real knowledge and experience in grand jury matters, to pre-screen, pre-digest. And if you happen to be in a jurisdiction where the court seems to be a bit resistant or hesitant or concerned that it might be delegating something that's non-delegable, have them call the presiding judge or the court executive officer in a county where you know that's actively going on, for example, in Shasta County.
Good morning, Judge.
I agree.
It's a long time since I've stood before you. As an advocate.
Thank you.
Kind of moving ahead to the end of the process with the grand jury, can you describe your view of the court's function when it comes to responses to grand jury reports? As they come in, they're directed to the presiding judge. But what happens in the court's practice or mind after they get there?
Well, you're testing stale knowledge of the law, but my memory is that the court actually doesn't have explicit authority to take action against an entity or an agency that's been the subject of a report. The court can invite a further response if the court is of the view that the response didn't directly address the points made by the grand jury in its report. I would say, as a practical matter, and this is one of the constant dilemmas that grand juries face and one of the continuity problems that are faced by succeeding grand juries, that generally speaking, the presiding judge is going to take a passive role with respect to the receipt of responses. I think the notion being that the responses are public, the report is public, the process is generated principally for the benefit and education of the citizenry, and it's the citizenry that's to make the final judgment. But there are instances, obviously, in which there's not a report that's issued, or there's a response, or a response that appears to be a deflection. And there, I think the presiding judge can become informally involved in prompting or encouraging, but that's about as far, at least in my experience, as the court has gone.
Thank you for the presentation, Judge. And I promise not to go back to my jury and tell them that the PJ doesn't know anything about the grand jury. But my question is, have you noticed any impact that technology has had on the recruitment of current grand juries? Most of us are in the north side of the computer age.
Roadkill on the information highway is the way I describe myself. And frankly, I don't possess much in the way of knowledge concerning that. I'm not sure, for example, what our local Grand Jurors Association does out of its website or by other electronic means to prompt citizens to apply. And I apologize for that. There may be others who are aware, and you're more than welcome to speak up if there are means that are being used to enhance the recruiting of new grand jurors that involve modern technology. Any hands on that? It remains a mystery to this day.
Back here.
Your Honor, you had listed several things that are good resources for a presiding judge. The only one that I was, well, two that I was aware of was the conference that the CGJA has for presiding judges and the notes from that conference. You listed several other things. My question was, and I don't know if you alone can answer it, would you please list those things and let me know how much they cost so that alumni chapters can potentially preside their presiding judges with the information?
Right. Well, there's the Compendium of California Law, which is essentially an index of statutes and case annotations to those statutes, which in any way, shape, or form pertain to grand jury activity, either criminal or civil. It was put together by CGJA. Karen is holding up a copy. It's not actually a ready reference guide or a how-to guide, but it essentially is a compilation of all of the statutory law with immediate references to any case authority that cited those statutes. So it's a handy document to have on hand as sort of a secondary resource. Then, of course, there's the manual itself, CGJA's comprehensive training manual that goes to all grand jurors who take CGJA's courses. As we all know, it's a monster and it is spectacular. The other source that I mentioned was a guide to supervising judges. It's about 35 pages. It's compact, very helpful, and it is a ready reference guide to judges. And then finally, there is the course that I think you mentioned too, that I don't believe is taught every year, but a course that is taught and has been taught to presiding judges, a brief synopsis of the responsibilities of the supervising judge for the grand jury. But the principal thing would be the compendium, the large manual, and then the memorandum that, as I say, is 20 some odd, 30 some odd pages. I believe that they're readily available through the organization, and I'm sure can be gotten to the judges in your jurisdiction. The manual probably costs something though, huh?
Right back here.
Morning, Your Honor.
Jerry?
As you know, we train most of the grand juries in the state. There are a few laggard, backward counties that we don't. No names. It appears to us in some of those cases, and maybe even the cases where we do train, but we train maybe not as much as we'd like to, that the judges seem to have delegated the responsibility for the training to the outgoing grand jury, who would need sometimes to perform the training in counties like that. It's almost to the point that some of us think that perhaps the judges may have even abdicated their responsibility to ensure training, as you cited earlier in your remarks. And I wonder if you have any thoughts about that or any comments of what more we might be able to do to bring these backward counties into the fold.
Yeah, you know, in any organizational setting, public or private, there is an element of territoriality. And the cultures of some organizations emphasize territoriality, turf, more than others. Some are receptive to ideas and practices that they willfully steal from other organizations because they're good and they work, and why reinvent the wheel? Others are resistant and wall building because this is us and we don't want anybody intruding. I think probably just that general notion applies to courts and certainly might apply to how some judges approach the business of educating grand juries. Rather than receiving or accepting assistance that's proven from the outside, they circle the wagons. To have outgoing grand juries provide training can be useful to a point, but unfortunately, if there are bad habits or practices that the outgoing grand jury adhere to, those will be passed on. To answer the other part of your question, what to do, it seems to me that affirmative outreach, uninvited outreach to those courts can do nothing but help. If you can get your foot in the door with someone who was the supervising judge for the grand jury in the preceding year, because some of the courts you're talking about are the larger courts that we have in the state, and just get an hour of their time to display the materials that we were just talking about, to give a little explanation, create a visual picture of what the courses entail and what the outcomes can be and how that can ease the burden on the supervising judge or presiding judge, I think is probably the best tactic to use with courts that are resistant. I'm not saying you're going to have a high batting average succeeding on that, but I think that over time you can succeed in winning some folks over because your product is good. Your product is good, it's persuasive. If you put that in front of a judge and you can get him or her to open it and start perusing it, I mean, they've developed an expertise in assessing the quality of resource material because it's their living, it's how they keep their heads above water. The materials speak for themselves, they sell themselves, but the difficulty is getting your foot in the door. I would just say that keep trying is the best thing to do.
Good morning. I wanted to follow up on Greg's topic of the responses. Interestingly enough, we had a training session in a county, not to be named, recently that told us their legal advisor said the judge has to sign off on the responses before they're released to the public. And I wondered if you had any comment on that, basically. We're not even sure if that's actually true, that that's what the legal advisor says, but it was kind of an interesting statement made, and none of their responses from last year have been published. So there could be some validity in it, but we don't really quite know what to do about it.
I'm not aware, and that doesn't mean that, in fact, there isn't now some statutory authority that empowers the presiding judge to serve as a gatekeeper for the publication of responses. That said, it may be, given the local culture of the court you're speaking about, that the presiding judge or supervising judge, as the case may be, takes it upon himself or herself to serve, in effect, as a de facto gatekeeper. To prohibit the publication of formal and otherwise procedurally correct responses is troublesome. But I can't really add to that.
Thank you, Your Honor. Given the important role of the foreperson, can you speak about how the judges vet and select a foreperson in general?
Well, I know that the local chapter of CGJA in our county urges the presiding judges, who of course come and go. 2 years in and they're gone, and then there's a new presiding judge, whereas the local chapter remains, there's continuity there. They suggest to the presiding judge that that selection process include conversation with outgoing grand jurors and with holdover grand jurors. Because generally speaking, the characteristics of grand jurors during a given grand jury year displayed in their participation and contributions will be an insight into what kind of service they might provide if they're selected as the foreperson. Which is not to say that all presiding judges follow that advice or select as foreperson somebody who's a holdover or carryover. And certainly if you have a carryover who's got suitable skill set, you're dealing with a known commodity. So that's the advice that our judges in more recent years have received, and it's, to me, sound advice.